The illusion of permanent security. Right now, across the globe, there is an American citizen who is completely unaware that they have embarked on a path that could result in the loss of their U.S. passport forever. Most people operate under the comfortable assumption that American citizenship is a permanent, unshakable status that is guaranteed for life once obtained. However, the legal reality as of February 2026 is far more nuanced and complex. Under existing U.S. law, there are established, fully enforceable legal mechanisms through which an individual can lose their citizenship, even if they have held that status for decades. Many individuals do not discover these vulnerabilities until they are already facing a crisis. Imagine the shock of making what feels like a routine, harmless decision, perhaps taking a specific job abroad, joining a local program, or signing a formal oath, only to find out later that this single action has placed your citizenship at risk. This script is not based on speculation or fear-mongering. It is grounded in the current statutory framework of the United States. Understanding these rules is essential for protecting your legal future and your rights in the United States. The two legal paths to loss of nationality. To understand how citizenship is lost, we must first distinguish between two entirely different legal procedures. The first path is known as denaturalization. This process applies exclusively to individuals who became citizens through the naturalization process rather than by birth. Denaturalization occurs when the government proves in a court of law that a person obtained their citizenship illegally, usually by hiding critical information, lying on an application, or committing fraud during the immigration process. This is a government-initiated legal punishment for those who broke the rules to enter the system. The second path, and the focus of our analysis today, is known as expatriation, or the loss of nationality. Expatriation is fundamentally different from denaturalization because it does not necessarily stem from government punishment for past fraud. Instead, it is the result of voluntary actions and personal choices made by the citizen themselves. The legal foundation for this is found in Section 349 of the Immigration and Nationality Act. This section outlines the specific acts that can lead to a person being stripped of their American identity. The constitutional shield, the power of intent. Before we examine the specific acts that can trigger expatriation, we must highlight the single most important legal principle in this discussion: intent. Under modern constitutional law, and following landmark U.S. Supreme Court decisions, American citizenship cannot simply be taken away by the government without the citizen's consent. Performing a potentially expatriating act is not enough on its own to lose your status. The government carries the burden of proving that the person not only performed the act, but did so with the specific purpose of giving up their U.S. nationality. This requirement of intent is the key that protects millions of Americans who live, work, and study abroad from accidentally losing their citizenship. The law starts with a strong presumption that a citizen intends to keep their status unless there is unmistakable evidence to the contrary. This protection ensures that citizenship cannot be lost through a technical mistake, a misunderstanding, or a simple administrative error. Reason 1: voluntary foreign naturalization. The first shocking reason someone can lose their U.S. citizenship is by voluntarily obtaining naturalization in a foreign country. If an American citizen chooses to go through a formal process to become a citizen of another nation as an adult, that act is legally classified as a potentially expatriating act. This often surprises people because dual citizenship is so common in the modern world. However, the law makes a distinction based on how that second citizenship was acquired. Being born with dual nationality or inheriting it through your parents is completely fine and poses no threat to your U.S. status. The risk only arises when a U.S. citizen makes a conscious, voluntary choice to apply for and receive citizenship in a new country. Even in these cases, current State Department policy does not assume the person wants to abandon their American nationality. In fact, the default assumption is usually that the person intends to maintain both. Navigating the nuance of dual nationality. While obtaining a second passport is generally safe, it becomes dangerous when the circumstances surrounding the naturalization show a clear intent to reject the United States. For example, if an individual applies for foreign citizenship and during that process makes formal statements declaring they no longer consider themselves American, the government can use that as evidence of intent to relinquish U.S. status. If an American signs documents explicitly renouncing all previous allegiances, including their allegiance to the United States, they are creating a serious legal liability. Conversely, if someone becomes a citizen of a country like the United Kingdom or Australia for practical reasons, such as better job opportunities, easier travel, or the ability to own property, and continues to pay U.S. taxes and maintain a U.S. passport, their American citizenship remains secure. The difference lies not in the second passport itself, but in whether the individual's actions and statements signal a desire to break their bond with America. Reason 2, swearing allegiance to a foreign state. The second reason for potential loss of citizenship is closely linked to naturalization, taking a formal oath of allegiance to a foreign country. In many nations, obtaining citizenship, taking a government position, or even securing certain professional licenses requires some form of oath or declaration. On the surface, this might seem like a betrayal, but the U.S. government recognizes that many of these oaths are merely symbolic or administrative formalities. The core analytical question is what that oath actually meant to the person taking it. If a dual citizen takes a routine citizenship oath to gain practical benefits, the U.S. government generally does not view this as an attempt to abandon their American identity. The danger arises when the oath contains explicit language rejecting the United States. If a person swears to renounce all previous allegiances and then stops acting like an American, for instance by refusing to renew their U.S. passport, the government may conclude the oath was a deliberate step toward giving up their citizenship. The legal weight of official ceremonies. When evaluating foreign oaths, the State Department looks at the totality of circumstances. Words spoken in an official ceremony carry more legal weight than many people realize, and the context matters immensely. Analysts look at whether the person continued to live as an American, maintained ties to the U.S., and continued to file U.S. tax returns after the ceremony. This is why two people can take nearly identical oaths, but end up with completely different legal outcomes. One may retain their citizenship because their intent was purely practical, while the other may lose it because they used the oath as a vehicle to signal their rejection of America. For green card holders who eventually naturalize, this is a vital lesson. You can maintain connections to your country of birth, but you must be extraordinarily careful that no official statement you make suggests an intention to abandon your hard-earned American status. Reason 3, serving in a foreign military. The third reason someone can lose their U.S. citizenship is by serving in the armed forces of a foreign country. This area of law is filled with nuance because the United States recognizes that many of its citizens have deep family and cultural ties to other nations. Not all military service is viewed through the same lens. The most severe and dangerous scenario involves serving in the military of a country that is currently hostile to the United States, especially if that service involves taking up arms against American forces. In such cases, the act is often viewed as fundamentally incompatible with American citizenship. However, thousands of Americans have served in the militaries of friendly allied nations without any threat to their status. Distinguishing allies from hostile forces. When investigating foreign military service, the law examines several specific factors. Was the country an enemy or a partner of the U.S.? Did the person serve as an ordinary enlisted member or as a commissioned officer? Did they take an oath that specifically rejected their American allegiance? As with all these reasons, intent remains the deciding factor. Without clear evidence that the individual joined a foreign military with the purpose of abandoning their American nationality, the government is unlikely to revoke citizenship based on service alone. For those already holding citizenship, choosing to join a foreign military is a weighty decision that could be interpreted as shifting your primary allegiance. It is one of the clearest examples where seeking professional legal advice is essential before making a commitment that could have irreversible consequences. Reason 4. High-level foreign government employment. The fourth reason involves accepting certain types of employment with a foreign government. While millions of Americans work overseas and interact with foreign governments daily, the law is concerned with positions that suggest a shift in primary loyalty. There are two main categories of employment that trigger scrutiny. The first category involves taking a job with a foreign government when the person is also a national of that country or when the role requires an oath of allegiance to that foreign state. The second category involves accepting a role that includes high-level policy-making responsibilities. These rules are designed to identify situations where a U.S. citizen appears to have transferred their primary political loyalty to another nation. Policymaking versus routine. Public service. It is important to clarify that routine, non-political jobs are generally safe. A U.S. citizen working as a language teacher at a public university, serving as a technical consultant, or working as an administrative employee at a foreign embassy is usually at no real risk. These roles do not raise red flags regarding allegiance. Serious scrutiny is reserved for those who become senior diplomats, cabinet ministers, or high-ranking officials responsible for shaping the policies of a foreign state. Even then, holding the job is not an automatic off switch for citizenship. The government would still need to prove that the individual accepted the high-level role with the specific purpose of giving up their American nationality. They look at whether the person continued to present themselves as American or whether their behavior indicated they now considered themselves solely loyal to the foreign nation. Reason 5, the formal act of renunciation abroad. The fifth reason is the most direct and deliberate, formally renouncing U.S. citizenship before a U.S. diplomatic or consular officer abroad. Unlike the other reasons we have analyzed, renunciation is not about guessing intent or interpreting context. It is a clear, intentional, and voluntary decision to terminate the bond of citizenship. The process is solemn and highly formal. A person must appear in person at a U.S. embassy or consulate outside the United States. They must sign official documents, take an oath of renunciation, and make an explicit statement that they no longer wish to be an American. The government ensures this decision is made freely and with a full understanding of the enormous consequences involved. Financial and legal consequences of renunciation. Renouncing citizenship is almost always permanent and irreversible. Once the process is complete, the individual loses the right to live in the U.S. as a citizen, the right to vote in American elections, and the protection of a U.S. passport. In many cases, even returning to the U.S. for a visit can become difficult or uncertain. There are also significant financial implications. U.S. tax law can impose exit taxes on certain individuals who give up their citizenship, and former citizens may have ongoing reporting obligations. People choose this path for various reasons: political beliefs, complex tax situations, or a desire to fully commit to another nation. However, for most, citizenship is the ultimate goal, and the law recognizes renunciation as a serious choice that is extraordinarily difficult to undo. Reason 6. Renouncing within the U.S. During wartime. The sixth reason is a rare legal exception that most people have never heard of: renouncing citizenship while physically inside the United States during a time of war. Standard renunciation must occur at an embassy abroad, but Congress created a special safety valve for extraordinary circumstances. This provision allows a citizen to give up their nationality from within the U.S., provided they follow specific procedures established by the Attorney General. Historically, this was designed for times of global conflict when travel abroad was dangerous and questions of loyalty were sensitive. While this rule remains on the books, it is almost never invoked in modern times. The government maintains broad discretion over whether to allow such a renunciation and conducts deep investigations to ensure the choice is not the result of fear or coercion. Reason 7. Treason, rebellion, and armed hostility. The seventh and final reason is the most severe and morally serious: committing treason, attempting to overthrow the U.S. government by force, or bearing arms against the United States. This category strikes at the very heart of the citizen-nation relationship. American citizenship is built on a shared commitment to the Constitution and a duty of loyalty to the nation. When an individual wages war against the United States or provides aid and comfort to its enemies, the law views this behavior as completely incompatible with remaining a citizen. In these extreme cases, intent is essentially built into the act itself. Unlike a foreign oath, which might be taken for convenience, acts like treason automatically demonstrate a total rejection of American allegiance. The rarity and severity of treasonous acts. The U.S. Constitution defines treason very narrowly, and actual convictions are incredibly rare because the legal standard is so high. It is important to emphasize that this provision only applies to truly extreme conduct. Protesting, criticizing the government, or engaging in intense political activism can never cost someone their citizenship. The United States strongly protects freedom of speech and political dissent. Losing citizenship for hostility requires actions that enter the realm of open betrayal, such as joining an enemy force or participating in a violent attempt to overthrow the government. For the vast majority of people, this reason will never touch their lives, but its presence in the law serves as a reminder that citizenship involves a basic duty of loyalty to the constitutional system. Presumption of retention. The citizen's safeguard. Having explored the 7 reasons, we must return to the most reassuring theme. The law is designed to protect your citizenship, not take it away. The legal framework is built around a presumption of intent to keep your status. This means that even if you perform one of the acts on the list, the government assumes you still want to remain an American unless there is clear proof to the contrary. This safeguard allows millions of Americans to lead global lives, working internationally, holding dual passports, and building careers across borders without the constant fear that a single mistake will cost them everything. Citizenship is treated as a constitutional right of the highest level, not a government benefit that can be revoked at will. Proactive steps to protect your status. Knowledge is the best protection against these shocking legal risks. If you are ever considering an action that might fall into one of these 7 categories, such as taking a high-level foreign government job or joining a foreign military, you must seek professional legal advice first. Do not rely on assumptions or internet forums. An experienced immigration attorney can help you structure your choices in a way that clearly protects your U.S. nationality. Being proactive allows you to navigate the boundaries of international life safely and confidently. The importance of visible ties to America. Another practical piece of advice for those living abroad is to maintain visible, consistent ties to the United States. These ties serve as powerful evidence of your intent to remain an American citizen. You should keep your U.S. passport current and renew it on time. You must continue to file U.S. tax returns, regardless of where you live. Whenever possible, maintain bank accounts, property, or family connections in the U.S. and visit the country regularly. These actions send a clear, documented message to the government that no matter where your career or family life takes you, you still consider yourself an American. Keeping good records of these connections is a vital safety measure should your intent ever be questioned years later. Final reflections on the duty of loyalty. As we conclude, it is clear that being an American citizen is about more than just a passport in a drawer. It is a lifelong relationship built on loyalty, intention, and responsibility. The 7 reasons we have explored define the outer limits of that relationship, but for the overwhelming majority, they will never be a factor. Whether you were born American or worked hard to become American through naturalization, your citizenship is one of the most powerful legal protections in the world. It is a bond with a nation and its ideals that is meant to be a stable foundation for your life. By staying informed, acting thoughtfully, and respecting the commitment you have made, you can ensure that your citizenship remains safe, secure, and strong for the rest of your life.